Looking to bring your foreign partner to the United States? In this video, we will cover 3 different ways on how it can be accomplished. We'll discuss fiancé or K-1 visa, spousal visa through consular processing, and adjustment of status inside the United States. This way, you will know the difference between these 3 options, and it will give you an idea on which route to choose for yourself. We will start this discussion with the marriage adjustment of status because it is its own separate path, and from there it will be easier for me to compare fiancé and spouse visas. The adjustment of status process allows certain individuals within the United States to apply for a green card without having to leave the US. This process is typically used by individuals who entered the United States on a temporary visa, such as a student or work visa, and now wish to transition to permanent residency. This basically means that both spouses are currently present inside the US, and they will be applying for their green card inside the US as well. Sometimes people confuse it with a change of status. Change of status is when you change one non-immigrant status to another. For instance, you entered on a tourist visa and changed your status to a student visa, or from J-1 visa, you went to B-2 visa. But adjustment of status is when you go from a non-immigrant visa to an immigrant status, or in other words, green card. The main advantage of this path is that both spouses get to be together inside the US while waiting for their approval, and the immigrant spouse can work inside the US and travel outside the US so long as they apply and get approved for work and travel permits. We receive so many questions regarding tourist visas that it's worth mentioning this. Individuals who enter the US on a tourist visa or ask the visa waiver can adjust their status through marriage to a US citizen. The only caveat is that these individuals cannot have a preconceived intent to get married and apply for adjustment of status at the time they enter on their tourist visa. I checked online the other day, and there's just so much misinformation regarding the 90-day rule online. Since the USCIS does not even apply this rule, and intent can be analyzed from so many different angles aside from waiting 90 days to get married, just know that the USCIS will not look at arbitrary dates, but rather what your intent was when you were admitted to the United States, regardless of the date. Boundless and other sources have some really outdated information, and they appear on top of Google searches, so couples are often misinformed on how to handle their specific situation. It's always a good idea to consult at least a couple immigration attorneys to get the most up-to-date information on this process. Now, you do need to know that although both spouses get to be together during this journey and applicants normally get their green cards relatively quickly, just an example from our marriage immigration method, it does involve a lot of paperwork. It is somewhat pricey. You will be submitting between 7 and 9 different forms and a ton of supporting evidence attached to each form. At the end, it will look like this. It will also cost you $3,005 in filing fees, in addition to up to $1,000 for a medical exam in certain states. If you plan on hiring a lawyer, you'd need to budget at least $5,000 to $7,000, although we've seen numerous quotes like $10,000 to $12,000 over the years, so that's not unheard of. Finally, the timeline. First, you need to watch our video from last week, since we go deep on how long the marriage adjustment of status takes. To summarize, it takes about 2 to 3 months to get a work permit, 4 to 6 months to get a travel permit, and normally under 12 months to get a green card. I have to mention that currently the USCIS is on fire, and we often get super fast 35, 59, 81-day approvals inside our program, and you can check all those interviews on our page, since we always go deep on the entire immigration journey and how it looks like. At the same time, you still need to prepare for this process to take some time. Too many variables to consider with the upcoming election, and we also can't expect the USCIS to process all cases that fast. Which, by the way, at the moment, we work exclusively with the marriage adjustment of status, guiding couples from right now all the way through naturalization, making this process significantly more affordable, significantly easier, and as stress-free as we can possibly make it. But our big vision is to cover the entire marriage immigration, and K-1 or fiancé visa plus spousal visa will be launched later down the road as well. Which brings us to the K-1 visa conversation. Look, there's so much information on this visa online that often couples think that the only way for them to be together is by taking this route, but it is not always the best idea. So let's start our conversation with a fiancé visa and what it entails. First, it's important to know that you cannot be married. This would only work for those who are engaged. If you are already married and your partner is overseas, you will take the consular processing route, and we will discuss it in a second. K-1 basically allows the foreign fiancé of a US citizen to come to the United States and get married within 90 days. It's a non-immigrant visa, which means it allows for a temporary stay in the US, and then you apply for a permanent residency when you're already in the country. Once you're married, the foreign spouse will apply for adjustment of status that we just discussed previously. The process will be slightly different since the foreign fiancé will not need to do the medical exam here in the US. It would have been done as a part of the K-1 process. Plus, you will not need to file Form I-130 so long as you get married within those 90 days. Thus, the filing fees for the adjustment will be slightly lower. But often couples actually end up marrying outside those 90 days, so they do need the I-130 as a part of their adjustment application. Speaking of the cost, you would pay $675 for the application, plus separately for the medical exam, US State Department processing, and all the expenses associated with the adjustment of status. Usually it's around $3,500, but can be over $4,000 in just government fees. Plus, if you're looking to hire a lawyer, they would normally charge you anywhere from $6,000 to $15,000 for the K-1 plus the adjustment of status. Obviously, not everyone wants to pay for an attorney, which is absolutely understandable, but you do need to know that 31% of K-1 visa applications were denied in 2023 and increased from 20% in 2022, meaning 1 in every 4 K-1 visa applications get denied. I think the biggest problem is people doing it themselves, but with no proper guidance. But we also often hear some really bad stories about immigration agents or notarios or paralegals totally messing it up. You need to ensure you fully understand the requirements. There is an important 2-year rule which is designed to ensure that the relationship between the US citizen and their fiancé is genuine by requiring couples to provide proof they've met in person at least once within the 2 years before they submit Form I-129F. It doesn't mean couples need to have been in a relationship or known each other for 2 or more years. It just means that before you send in your application, you must have evidence that you physically met at least once in the last 2 years. Now let's talk about timelines. First, we've seen super fast I-129F approvals lately. 2 months approvals all over the place. Although it can easily take 12 to 18 months, normally it's about a year. But the processing time is not the most important point here. What matters most, and what you do need to take into account when deciding on whether to take this route for yourself, you just get a visa. And from there, you will still need to apply for a work and travel permit, meaning you won't be able to work and travel outside the US for some time, and green card after you enter the US and get married, while the spousal visa, the process we're about to discuss next, gives you a green card and thus an ability to work right away. The K-1 process costs more, and although you would normally get K-1 visa faster than the spousal visa, there is a lot more that needs to be taken into account when making that decision. It might be the right path if you want to be together as soon as possible. If you can wait, then getting married and going through consular processing might be a better choice for you, but let's get into it. A CR1 spouse visa, also called IR1, allows someone from another country to live in the US with their spouse, a US citizen or permanent resident. CR1 or conditional resident visas are given to applicants who have been married to a US citizen for less than 2 years. These visas are granted on a conditional basis. 2 years after you arrive in the United States, you and your US citizen spouse must apply to remove conditions on their green card, at which point you will receive an updated 10-year permanent resident card. On the other hand, IR1 or immediate relative visas are given to those who have been married to US citizens for more than 2 years. In this case, the IR1 holder does not need to remove conditions as there are none. Talking about the cost, this is normally a more affordable way to get a marriage green card, but it can easily get expensive if you've lived in many countries for 6 months or more, since you will need to get police certificates from all of them. You would pay $675 for Form I-130 or $625 if filing online, which you should when it comes to consular, since you will instantly get your receipt number and the USCIS will begin processing it. Plus, you need to pay $325 for processing the immigrant visa application, medical exam, which can vary, and there will be some additional expenses in acquiring necessary documents, translating paperwork, and you need to take into account all the associated travel expenses, plus the legal fees if you end up hiring a lawyer, which will easily cost you $5,000 plus. When it comes to timelines, it will depend on the country, of course, but either way, it's best to prepare for at least 2 years. 18 months is the bare minimum if there are truly no hiccups. Again, if you're trying to decide between a fiancé visa and consular, you can't just think about timelines. You also need to consider if you want to get married and be separated for 2 years. You know, this idea sounds really weird to some couples, and if neither of you feel like being a married couple but living separately, then perhaps a fiancé visa might be a better route. Maybe you're not even ready to get married so soon. It's all very personal, but so long as you understand how these 3 options work, You both can decide what would work best for you as a couple. Oh, an important note. If you're considering consular processing, look into direct consular filing. It allows a sponsoring spouse to file Form I-130 directly with the consulate. This process is often much faster compared with filing Form I-130 with the USCIS lockbox facility in the United States, but direct consular filing obviously has limitations. For most spouses seeking a green card, direct consular filing is only available if the couple meets all of the following conditions. The sponsoring spouse is a U.S. citizen currently residing outside the United States for an extended period of time. The sponsoring spouse can prove that they're temporarily living in, not just visiting, a country other than the United States. The sponsoring spouse's permanent home is or will be in the United States. The couple has an exceptional circumstance. This is very important. For example, a medical emergency affecting either the sponsoring spouse or the spouse seeking a green card and requiring urgent travel. This might include a pregnancy where the expectant mother will be unable to fly. A military deployment, but only if the military service member received far less notice than normal. A change in employment, but only for a sponsoring spouse who is a U.S. citizen living abroad and whose work or job offer requires them to relocate to the United States on a short notice, or a threat to personal safety if either the sponsoring spouse or the spouse seeking a green card has credible fears about their security. Look, it's not easy to get the consular post to accept directly filed Form I-130, but it happens. It can work unless the international USCIS field office is available in the country where the sponsoring spouse currently lives, and here's the list of them. Still got questions? Drop them in the comments. Otherwise, like this video and we'll see you next week.